Hi, everybody. Welcome back. This is Jennifer Phillips Russo. You are listening to Between the Vines. Our podcast is brought to you from the Lake Erie Regional Grape Program, which is a partnership between Penn State University and Cornell University. We are located in Western New York, and we handle 4 counties in New York State and 1 county in PA. During the flux of our program, we have had special guests if you have been following along. And today we have a very special guest, Dr. Richard Stup. He is with Cornell's Agricultural Workforce Program. And we have had a lot of, in Kevin Martin's absence, most of you who will listen to this know that he was a business management specialist who has now joined the grower side. We've had a lot of business questions brought our way. And I thought, why not just go to the guy who knows the most about it in my book? So I've invited Dr. Stup to join us today. Thank you for coming on.
Oh, thanks, Jen. It's a pleasure to be here.
I should also add that he is also a PSU and Cornell extension specialist in his whole career. So thank you.
It's nice to make those 2 connections.
So before we get started, is there anything that you would like to say about your background and your position that I guess might, so our growers know that you're qualified to discuss this information?
Oh, sure. Yeah. So, so I did my PhD at Penn State, and I did that in workforce education and development. And so that's, there aren't too many of us that are Aggies, that work in this field that actually have a background in something like workforce development. I'm one of them. I've spent a whole career in agriculture. I grew up on a farm and all that sort of stuff, and have worked in industry and academia throughout my career, but always working with producers, helping them develop their businesses. But really, in the last, it's 20 plus years now that I've had a really strong focus. Yeah, it's actually 23 years that I've had a really strong focus on employee management and leadership development, those sort of things. And so, yep, the big thing, and certainly in recent years, labor has become a huge issue for all sectors, all commodities. Some folks have permanent year-round employment, some folks have seasonal employment, and a lot of folks have both year-round and seasonal. And so H2A comes in for the seasonal operators. And so I've worked with a lot of different sectors on that as well. So yeah, look forward to being here with you. I'll share just a little bit more. We've kind of expanded the program in the last few years, added some staff. Many of you may know that we've been teaching supervisory leadership courses. These are online courses. We're getting ready to offer that in Spanish as well for Spanish speaking folks that need to be better supervisors. And we've also been doing a lot of work in things like apprenticeships, helping people to advance their careers that way, but also in employee housing. So working with producers on better managing, building technical assistance with on-farm employee housing.
That's fantastic. And I look forward to sharing articles that you have in regards to all of that with our growers, because we've had questions on basically everything that you've mentioned thus far. I had one thing that sparked our conversation. We had a grower reach out, and I know that we're going to talk a lot about H2A today because H2A is huge in labor in our, not every sector that you said, not only ours, but we also had some questions in regards to unionization of labor in agriculture. And right. I can speak to you. One of our growers submitted a question stating that there are currently, he thought, 5 active petitions, and another one that has been certified on Long Island, and wanted to know, what can growers legally say and not say? Do you want to speak to any of that? That would be helpful.
Right. Yeah. So that's a really important point. So we don't know, we don't have a way to directly track how many union organizing campaigns are going on. And as we know, the way things work in New York farm labor unions, that organizing can be done without the grower even knowing it, until the state notifies the grower that there's a union campaign and that the organizers have 50% or more of the employees who've signed an authorization card. So yes, there are at least 5. I would say there's many more than that that are somewhere in the organizing process. And now it's I believe all over the state. There have been farms, both vegetable farms and dairy farms that I know of in Western New York, certainly in Central New York, and definitely in the Hudson Valley, and of course on Long Island. Long Island was the first one. That was a winery down there, and that farm did get organized, and they have for the last year been in the contract negotiation process. Now that's taking way longer than it was supposed to take. And there's a lot of turmoil around that whole part of the process, which is to be expected since it is the first one. But to my knowledge, as of this date, there are no contracts in place yet. There are farms that have been certified and have to be in the negotiation process with unions, but that's where we're at. And I would say, to sum that up, there's no part of the state that does not have union activity taking place.
Okay, so it is taking place. What now, once they're notified, is there some things that they can and cannot say that could, I guess, get them in trouble? They're trying to avoid
for sure. So yeah, so there's two there's two kind of rules of thumb that we use to help growers understand what they can and cannot say. Now, this is actually throughout the whole, even before organizing takes place, and this will make sense when you hear about it. But especially once you know organizing is in place, then you really especially need to be careful about what you as the owner, plus those that are managers, hired managers out there, supervisors, anyone who is even one step above a frontline worker needs to follow these rules. So that's an important thing to keep in mind. It's called T.I.P.S, T-I-P-S. So TIP stands for threats. You can't, T is for threat. You can't threaten people and say, well, I'm going to close the farm. I'm gonna fire everybody. I'm gonna do this or that if a union is formed here. So threats like that are it's called, all these are called unfair labor practices. You can't do that. The next one is I, interrogation. So you might want to know what's going on, and you might want to talk to your employees and ask them questions about who's organizing, when is their meetings, and things like that. That's interrogation, and you just can't do that. Now, can an employee come to you as a manager and talk with you? Yes, they can come and ask you questions, but you have to be really careful about asking questions of the employee. So that's where it's at. You can have a conversation with them, but you can't ask them questions. You can answer their questions. P then is for promises. So if you ordinarily give raises, you can continue to give raises. You can continue to work with people as you normally would in your normal course of business as an employer. But you can't do kind of extraordinary promises like, hey, if you don't sign up for this union, we'll take care of everybody. We'll make sure that you get extra raises, or that you get a bonus, or that you get all the time off that you need. You can't make promises of that nature with the intention of preventing a union from forming. And then the S in TIPS is for surveillance. So you can't spy on your employees. That comes, it's related to the interrogation. You can't do other things like suddenly you install cameras, at the farm to see who's coming and going. You put cameras at the worker housing to see if there's organizers showing up. Suddenly you do that. Now, people have cameras at worker housing, and often it's for security reasons, and that's okay. I'm not telling you to take your cameras out. I'm just saying that you can't do it, in the midst of an organizing process in order to spy on employees. You can't find out where that meeting is at the coffee shop in town and then drive by with your camera and take pictures of the cars and license plates to see who's there. None of those sort of things are allowable. So that's TIPS. But let's turn that around, and there are a couple of things that you can say, and that's called F.O.E. And so the first one, F.O.E, I'm going to look at my my notes here. F is for facts and F.O.E. And so you can share facts. You can share the fact that, hey, unions are not free. There will be dues that the union will charge, and the employer will take that out of the paycheck, and that will go to the union. So that's the F in it, and that's one of the facts. If there were example union contracts. There aren't many yet because this is so new, but you could share that. If you had other experiences, people that maybe had experiences with the unions, and if you're trying to prevent a union from forming, and people weren't happy with that union, you could share those kind of facts, and that kind of leads over into opinions. As an American citizen, you have First Amendment rights of free speech. And so it's important that those not be infringed in any circumstance. And so remember, you can't threaten, but you can certainly share your opinion. If you're an employer and you don't want a union to form, and your opinion is that, hey, I think it's better if we talk to each other directly, that we have this close kind of family relationship around here, and that if a union is involved, it's going to get in the way and interfere with that. If that's your opinion, you can share that with your employees. And in fact, you should, because employees, they don't know how you feel about something unless you tell them. And so that's part of the opinions. And the last would be examples. And so again, that's things like union contracts or other people that have been dissatisfied perhaps in a union situation. So you still got the tips, are the things you can't say. F.O.E. are the things that, yes, you still can say.
Thank you for all that. That is great advice. I'm just sort of giggling that F.O.E. seems positive and it has a negative connotation to it. Yeah. Okay. I think that we've answered the questions for that grower in regard to unionization of agricultural workers. Thank you for that. Is there a website where the tips and F.O.E.s information is available that you would like to share?
Yeah, I'd like to share two websites. One is our website for the Cornell Ag Workforce Program, which is simply agworkforce.cals.cornell.edu. Or you can just type in your Google, just go Cornell Ag Workforce, and it will come right up. The other one is New York Farm Bureau's website. So I know many of the listeners will be Farm Bureau members. Look on their website for information about unions. They've got some excellent resources on there, resources from attorneys. And actually, that's one other point I would make, Jen, is that if you find yourself with an organizing campaign taking place, you need to contact an attorney. You need to talk with that attorney. Yes, it's going to cost money, but you're going to save a lot of money by avoiding some pitfalls in your particular situation. So it needs to be an attorney that understands unions, in particular New York Farm union law. I believe there's some references on the Farm Bureau website. And if they want to reach out to me, I know several that are active in that area as well, and I can refer them. So don't try to go it alone, and don't try to save a few bucks by going it alone in this particular area. If there's a union organizing campaign, please do get in touch with an attorney as soon as possible.
Great advice. Thank you. So let's shift gears just a little bit and talk about, unfortunately, this is not a new subject. However, there are some new questions in regards to the H2A program. Many of our growers in this area are finding it increasingly more difficult to find labor. And that's not just growers, like you had mentioned, it's across commodities.
Yep.
Just commodities, but all labor department, I feel, is experiencing the same thing. They're curious because many of ours have decided to collaborate and form collaborations to bring in H2A and share the group that comes in. And now we're hearing that they no longer can, and it's making people very nervous. Oh, we have okay, upcoming H2A changes.
Okay, yeah, these are two particular issues. And I want to say up front that these are very technical. They're very complex, and those growers out there who have used H2A, you understand that is kind of how the program goes. It's technical and it's complex. That being said, it is the most important source right now of new labor, new employees to agriculture because it's just so difficult to find people willing to work from in on farms from any other source. Locally it's difficult, especially when you've got unemployment that's running down in the threes. There's just plentiful jobs available, and so H2A is where things have come about. Um, so a couple of things that I wanted to share with you. So this issue of joint employers. So some employers are big enough that they can file on their own, and they've got enough work to keep people busy, throughout the growing season or whatever makes sense. Now, I understand that some employers, you don't have to have all of your employees come on one work order. Each employer can have more than one work order. So let's say, for example, that you've got some work that's during the spring and summer, but then in the fall you've got a bigger need for additional work. So you could have some of your employees come in for the whole season, and then you could have another group of a larger number of employees then come in just for the fall season for harvest. So an employer can do that, and it's important to know that you don't have to keep everybody busy for the same period of time. You could have more than one work order in that case. But sometimes that's even not enough flexibility. And so there are growers who have worked together. So two or three will go together and and make an application that was a joint employer application. And that has become more popular and in recent years. And there's some downsides to it. And one of the really important downsides is that, as we know, there's a lot of rules with the H2A program. So if you're in a joint employer relationship and you you need to understand the business practices of your partner very well, because if your partner breaks any of the rules and ends up getting a fine, both employers are liable for that. So all liability goes with both. So make sure that your partner is a good, trustworthy person that's going to follow all the rules and follow through on that. And that applies to any situation. So something has happened in that last year, the U.S. Department of Labor started to make some changes to several of the H2A rules, and this joint employer rule is one that they did make some changes in. So yes, it is technically still possible to file in this joint employer status, but there was a final rule was published on March 14th, where USDA limited the hours that multiple employers can offer H2A employees in joint employer job orders. So in other words, basically, it's confusing in technical language, but it basically says that no single employer within that joint employer group can offer more than 34 hours in a week to any one employee or group of employees. So if you think about that for a minute, what if you have a week where you've got a lot of hours that you can offer, and the plan is for this one employer to have the group of employees working there for 50 hours that week? Well, you can't do it under a joint employer status anymore. So and I just don't understand why U.S. Department of Labor made that change for employers that are smaller and that are using the joint employer status because they only have, let's say, 20 hours a week, and it's going to be consistent. And then they've got a neighbor that's got another 20 hours a week, then it might still work to use the joint employer status as long as those hours are relatively consistent and they're going to stay. No single employer is going to have over 34. But you can see how that really limits your flexibility and ability to move workers around. They're going to be working at this place for this week and that place the next week and that sort of thing. So what employers are doing who have used joint employer status in the past, they can't use that joint employer status. They've started to switch to another kind of title of eligibility, which was called an agricultural association. It wasn't used very much in New York until just the last year or two. It was used in other states. For example, in North Carolina, there's a very large group that basically brings in most of the workers for the whole state, and it's an agricultural association. So this agricultural association term was thought of as kind of for bigger groupings like that. Well, it turns out it can be for just small groupings of two or three growers going together. and or more. So you can form an agricultural association and apply in that way, and it doesn't have the restrictions on the hours that the joint employer status does. So
Huh.
I've talked about that in a relatively simple way, but it's complex. And so if you want to explore that, I encourage you to talk with your consultants, your H2A folks you work with, and attorneys about the agricultural association route.
And does basically all of the same principles apply except for the ones that you're saying are now being blocked, like they have to share housing and they can't go over, did they take it down to 40 or is it 60 hours now?
So overtime would apply. Yeah. So so what you're getting at there is overtime. Right now, we're still at 60 hours for any employer, including an employee, including H2A employees. So we're at 60 hours as of January 1, 2024. Then we'll drop down to 56 hours for overtime.
Okay.
Yep.
It's a decrease there somewhere. Thank you.
Yep.
So I'm not trying to work a system. I'm just trying to help my growers get information. You
Mhm.
say that it's quite possible to get what they're expecting by forming an agricultural association, and they need to go through their attorneys and the people that they work with, the contract people for H2A.
Exactly. Yep, that's right.
Perfect. So I know this is, and I'm not sure how much you can share or not share. And I also don't want to just jump, just put you on the spot about some things. But if I do say, I really just don't want to talk about that, and I will.
Okay.
There are things that I've heard from my growers or questions that have come in where they have shared workers and they had to be very specific in regards to what you want people to do, for instance, on the contracts. For instance, if they're coming in our industry, we're getting them for work to tie grapes and prune grapes. That if you make sure you put some mechanic work on there, then on days when they absolutely cannot get outside, then there's other jobs that they can do and still get paid for.
And well,
First of all, is that a yes or no?
that's a good segue too into the next thing we need to talk about, which is how they've adjusted wages. So now interesting that you said mechanic work. I hadn't thought about that one, but that one would probably be an issue as well. Let me take one step back and explain where I'm going with this. So for years, we had H2A workers had to be paid the higher of several types of minimum wage. It could be the state's minimum wage, it could be like the prevailing wage for that type of work, or it could be the what's called the AWARE, AEWR. It's the adverse effect wage rate, and that is set by U.S. Department of Labor each year, and it's relatively high. And But it was the same wage and essentially was the minimum wage for each state for H2A workers. Well, USDA or USDOL saw that there were people working in other jobs as H2A were H2A workers were coming in, they were doing some other things. And so things like mechanic work is a possibility, but definitely things like, driving heavy trucks, construction work, some types of supervisors. And then another one that's come up a lot is what we'll call kind of van drivers or
Chauffeur.
yeah, chauffeurs. Yes. So that term comes up, although it seems out of place on a farm, but it does come up. Um, so, um, so with this situation where these different jobs that were coming up, U.S. Department of Labor decided that okay, the farm labor survey that was done by USDA, and which was used basically this to set the AWARE, wasn't really representing some of these other jobs, and so they made a decision that they were going to go to a different set of data. So there's a U.S. Bureau of Labor Statistics that gathers occupational employment wage survey, OEWS. So this is a new acronym we've been hearing. And that data is about all sectors of the economy. So all kinds of employees out there are tracked, and their wages are tracked under this OEWS. And it's a huge database that you can download from Bureau of Labor Statistics, and it has everything in there. So this final rule went into effect March 30th, and I'm not going to get into the details, but as time goes by, we've got more and more job orders now that are covered by this. But some of these jobs, again, like the chauffeurs and the building and construction and so forth, are now going to, instead of being paid the AWARE, they're going to have to be paid the OEWS wage. And so that's had an impact. So let's look at what a couple of these jobs are. I want to talk for a moment about the core 6 jobs. We're going to ask something, or?
Yeah, I was going to ask something, and I apologize to jump in. Is it possible when you're setting up these particular contracts that one person, one H2A person that you bring in, can fit both types of contracts? Like if you did a chauffeur contract for a certain amount of hours, and then a farm worker contract for another certain, can one person be in both contractors that they always have to take the higher amount?
So here's how it gets really tricky, right? So for each job, if it's going to be an individual job, it has to be for at least 35 hours.
Oh my goodness.
That's one of the long-standing rules. That's always been there.
Okay.
So can you bring someone in to be a chauffeur and nothing else, or a driver and nothing else? Well, if you've got 35 hours of work, maybe so. Maybe you can bring that one person in, and all that person does is drive people around. Not many farms really have 35 hours of work driving people around.
Yeah.
So that it's not going to work very well that way. And the reason that that's a problem is, let's say it's a normal situation where, okay, you've got one person that's been coming for the last 5 years since you've been doing H2A, and that person has a CDL from Mexico, let's say, and that CDL is valid in the US, and so they can drive the bus that you have to transport workers around. But when they're not driving the bus, let's say they're driving the bus for 20 minutes at the beginning and the end of the day, when they're not driving the bus, they're out there working as a normal worker. The problem is, if you leave that employee in the overall job order with all the other employees, 2 things happens. One, you have to use the bus driver wage. You have to use that wage for that employee, for that one employee that is the driver, for every hour that he works. But unfortunately, it's even worse than that. So everybody that comes in on the same job order also gets every hour at that higher wage. So that makes it completely unworkable and a real problem for people.
Right.
And that's what, and as I started to mention at the beginning, I think there are lawsuits. So the National Council for Ag Employers has a lawsuit that's very active, and it could put a stop to all these changes, but we don't know. The nature of lawsuits is that you don't know until the judge makes a ruling what's going to happen. And I had just heard yesterday that there's multiple other lawsuits challenging the same rules. So we'll see where it goes, but the rules are, in effect right now. My understanding is that July 1 is when these wage changes would be effective. So let's talk about the wage changes just to fill that in a little bit more. So there are what's called these kind of core 6 agricultural job codes, and I'm using the term SOC, SOC, which is Standard Occupational Classification. And so the 6 SOC codes that are the traditional H2A workers are graders and sorters of agricultural products, agricultural equipment operators, farm workers and laborers, crop nursery and greenhouse, farm workers, farm ranch and aquacultural animals. So that's those last 2 were the typical crop nursery and greenhouse, and then the aquacultural farm and ranch. Packers and packagers, so people that are packing things by hand, and then agricultural workers, all other. So that's the core 6. But you didn't see anything there about drivers. You didn't see anything about construction, anything like that. These core 6 are all at the traditional AWARE, which in New York this year is $16.95. So I pulled out a couple of other examples, and these are New York numbers. But when I pulled up first line this is the OEWS data. And when I pulled up a SOC code called First Line Supervisors of Farming, Fishing, and Forestry Workers, so this is a supervisor, that minimum wage is $29.99. So that's quite a lot higher.
Quite a lot.
Yeah. So if we look at a heavy and tractor trailer truck drivers. So you got somebody that most of the time they work in the field, but when that load is full, they take it to the co-op, and it's a semi truck, requires a CDL. That worker then would be at 26.63 an hour.
Wow. So technically, from what you said before, if you had one of those, the entire crew gets paid that wage for that day.
If they're all in the same job order, yes. And if it's just
Mhm.
one person, then he gets paid that all the time, whether he's picking grapes on the farm or whether he is driving the truck. And, common sense would say, well, okay, let's pay him that, but only when he's driving the truck, right? That's
Right.
what common sense would
Right.
say. But unfortunately, that's not how the rule is being interpreted right now.
Yes.
Shuttle drivers and chauffeurs, 19.52 an hour, and construction laborers, $29 an hour in New York. So you can see how this would really dramatically drive wages up.
Yes.
And this is a couple of notes here, but we've talked about most of that, the issues here of how it really drives prices up. So, one other point is that if you have any workers there then that are in corresponding employment, so that means any employees that you have, they're doing essentially the same work as what the H2A workers are. There's always been this rule about corresponding employment, so they have to get paid the same as the H2A workers. So if you have a situation where those other workers are doing the same thing as your H2A workers who are bumped up to that higher wage because one of them is driving the van, well, that means that the corresponding workers also have to be bumped up to the higher wage rate because of this rule with H2A workers and corresponding workers.
It's very, very complicated.
It certainly is. Yeah, so some strategies that people have started to do is to try, okay, so if you have a supervisor, maybe you bring that supervisor, just that person in on just one job order for that supervisor. But then again, that person needs to be a supervisor all the time. So how much time can that person be working in the field? And most of our supervisors are working supervisors. They're working at the job and supervising others. So it makes it difficult for that. Can you have a separate job order for a driver? Well, you probably don't have enough hours for one person to be a driver in that way. So some strategies are things like maybe we find local workers just for those things. Find somebody local to drive that van and be a chauffeur for the workers. Or if it's heavy truck drivers, we got to find local people, and we'll use the H2A just for those core 6 jobs. And then the other strategy, of course, has been to fight it, and that's what's happening. There are lawsuits filed to see how that might play out in court.
There's so much to think about, and I'm very appreciative of you joining me today to talk about this. Are there any questions that you've heard from other agricultural commodities that I may not have addressed? I know there are some that I won't even bring up in regards to, housing and labor laws not conflicting between federal and local. Are there things that people have asked that I have not asked you, so I don't make sure that my growers are aware as well without knowing what to ask? You don't know what you don't know, right?
I get questions all the time. Maybe, and this might be relevant in your industry a little bit, is processing. I think it's important to remember some of those rules. If you got on-farm processing of any kind, as long as if you're using farm laborers, and we're talking about New York State law now, but this applies to H2A as well, because we're talking about the overtime rules. So farm laborers, we're subject to overtime at 60 hours, but other industries overtime begins at 40 hours. So if you've got a packing shed of some kind of on-farm processing, and as long as you're only processing or handling your own product that you produce on your own farm, it's the farm labor rules that apply. So overtime's at 60 hours currently. As soon as you bring in someone else's product and you pack it in your facility, now it's a manufacturing facility and the 40-hour overtime applies. So keep that in mind. And typically the way people handle that is you can if you bring somebody else's product in, you're only at 40 hours for that week when the other person's product is in. And so that's basically how they break it down, is it's a week when you're a manufacturing facility, but then if you're handling only your own product, then it can be farm labor again. So that's one that people often struggle with.
Do you find that that's mostly like H2, is it H2AB or is it H2B?
So mostly what I deal with is H2A, and what I just described there, that certainly applies to H2A labor as well as local domestic labor. H2B is, for other industries. I don't really get involved in it. The closest that industry to us in agriculture that really uses H2B is like landscaping. So it's pretty similar jobs to agriculture, but they have to use H2B rather than H2A. And also there might be some manufacturing, some agricultural processors that definitely aren't farms that might use some H2B as well.
Okay. When you were talking about possibly maybe custom packaging in somebody's winery, I was wondering if that was still H2A or if that might be H2B for some reason.
If it's custom packaging and it's definitely not farm labor at that point, they probably can use H2B. The challenge with H2B is that it has a cap on it each year. It's limited the number of positions that can come into the country under H2B, whereas H2A, one of the best parts about H2A is that there's no cap. There can be as many H2A workers as people apply for and get approved to bring into the country.
Thank you. One last question, and then I'll let you go.
Sure.
I appreciate all of your time. Is H2A basically guarantees that you will have labor as long as you have, I believe, a 75-day lead for contract. Does that sound right?
Yeah, I think it is 75 days. I have to look that up to be sure of it. Yeah, so as long as you apply in time for your labor, some of the basics of H2A, remember, you have to pay for housing while they're here. And that's a big roadblock for people that are new or considering H2A but haven't done it. You got to provide housing. That housing has to be inspected. It has to meet certain quality. You can check our website as a good place to get started on some of those housing issues.
My next question.
Yeah. But another part of H2A that makes it expensive is just, you've got some fees that are directly associated with the program. You've got fees that are related to the visa that the employees have to get to come into the country. Likely in the first few years, you need to work with someone, a consultant of some kind, to help you through the process, because it's very some people do. If you're really good at paperwork and you're really good at reading the details, you can probably do it on your own, but most people end up using an attorney or a consultant to help them out, at least until they learn the program and can do it on their own. So there's a cost there. There's also the cost of transportation each day, and there's the cost of transportation into and back out of the country. The employer has to cover all of that. So H2A is not cheap, but and I won't use the word guarantee, that's a little too strong, but it's a very reliable source of labor. And that's why people get into it, or increasingly getting into the H2A program, is because there's not really any other game in town, and they can access labor. And another, while we're talking about that, once people get into H2A, they tend to stay in it. And they do tend to get the same workers back from year to year. It might not be 100% of your crew, but let's say you brought 8 or 10 people in. Typically, as long as you're a good employer, you've got good quality housing, and you're a decent person to work for, you're going to get 7 or 8 of those people back. Things happen. Some people, for whatever reason, life changes, and they don't want to come back this year. Maybe you have to use a recruiter to fill your H2A crew in the first year or two. But once you've got that core crew that's been coming for a few years, their skills develop and they get stronger. They know where the equipment is on your farm and where the fields are and how you like to do things. And so their ability and efficiency grows as the years go by, especially if you develop and help them to grow as employees. And then typically, if someone's not going to come back in the following year, very often that crew will find someone that can fill that slot. So recruiting becomes easier once you've become established as a good employer and a good place to return to.
That's good. That's good news to hear from you. And I've heard from growers that first couple of years are definitely bumpy and rocky.
Mhm.
but it does get easier and easier. And seems, I don't want to call it pay for themselves, but just even the peace of mind of knowing that the work is getting done is a little bit
Yeah.
of a, you can breathe a little easier.
Yeah. I've
Well,
heard
take
that it's typically
sorry.
a 3-year learning curve getting started.
I've heard that too, which might seem daunting, but 3 years compared to the frustration of not being able to find anybody and doing it all yourself may be
Right.
worthwhile.
Yeah.
Well, thank you so much for taking your time. I would like you to plug your website one more time.
Okay. Thanks. Yeah. Check out our website. It's simply agworkforce.cornell.edu.
Thank you. And a lot of this information, I am guessing, can be found somewhere on that website, or at least reach out to someone on that website to find more, correct?
Absolutely. Yeah. So glad to help folks. Glad to reach out in this way and be able to interact with folks. And Jennifer, it's always great to work with you and your team.
Thank you. And if anybody who is listening happens to have questions that you may have think of after hearing this podcast, please feel free to email me and I can forward them on and get answers for you. Also, feel free to comment below if you're watching this on YouTube, and we'll try to address those questions as well. And thank you so much, Dr. Richard Stup, for being here with us today and going over a lot of these complicated nuances that happen with H2A. However, I still feel that it is a beneficial program.
Absolutely. Thank you. It was a pleasure.
All right, everybody. We look forward to having you back next week, and we hope you all stay safe and healthy. Have a good week, everyone.